Start. The revenue is in an appeal against an order of the Income Tax Appellate Tribunal under Section 260A of the Income Tax Act 1961. The assessment year to which the appeal relates is assessment year 2009 to 10. The tribunal has allowed the appeal filed by the assessee on the ground that the basis for issuing a notice under Section 148 for reopening the assessment has not been fulfilled, since the assessing officer must have reason to believe that income has escaped assessment. The following questions of law have been formulated by the revenue: whether on the facts and in the circumstances of the case the Honorable Tribunal was justified in quashing the reopening of assessment by ignoring the fact that the assessing officer had sufficient reasons for reopening the case and accordingly assessing the long-term capital gains at rupees 72 lakh against the returned long-term capital gains of rupees 1,72,000. Whether on the facts and in the circumstances of the case the Honorable Tribunal was justified in law in not appreciating the fact that the assessment officer had valid reasons to believe that there is escapement of income by the assessee who, void his return of income, had shown highly inflated cost of construction and improvement. Whether on the facts and in the circumstances of the case the Honorable Tribunal was justified in not appreciating the fact that the value of property decided by Civil Judge Kanpur at rupees 1 lakh as per the court decree was rightly adopted by the assessing officer. Whether on the facts and in the circumstances of the case the Honorable Tribunal was justified in not appreciating the fact that the assessee during the course of assessment proceedings failed to produce evidence regarding cost of construction and improvement as claimed by him in his return income. The notice of reopening under Section 148 was issued on the ground that the assessee had sold certain immovable property for rupees 31 lakhs, whereas the value of property for the purpose of stamp duty was rupees 82 lakhs, resulting in an apparent difference of rupees 51 lakhs. It was on this basis that the assessing officer sought to reopen the assessment by issuing a notice under Section 148. The tribunal has observed that before the assessing officer can reopen an assessment under Section 148, there must be a reason to believe that the income has escaped assessment. As a matter of fact, in the present case, the finding of the tribunal is that though the sale consideration was rupees 31 lakhs, the value for stamp duty purposes as per the circle rate applicable was rupees 82 lakhs. In the computation of income, while computing the capital gains, the assessee had taken into account the higher value of rupees 82 lakhs. This factual finding of the tribunal has not been disputed by the revenue. Under Section 147, the assessing officer, before proceeding to reopen an assessment, must have reason to believe that there is an escapement of income from assessment. Now, it is well settled in view of the decision of the Supreme Court in the case of CIT versus Kelvinator of India Limited that under section 147 an assessment cannot be reopened merely on the basis of mere change of opinion, but there must be tangible material before the assessing officer to come to a conclusion that there is an escapement of income from assessment. Reasons, as the Supreme Court observed, must have a link with the formulation of the belief. This decision was, of course, rendered in the context of the provisions of section 147 as they then stood, but the fundamental principle is that there must exist reasons to believe that income of the assessee had escaped assessment, and there must be a rational and intelligible nexus between the reasons and the belief. In the present case, the submission of the assessee before the tribunal as recorded in paragraph 3 of the impugned order is that the only reason which was given by the assessing officer for initiating reassessment proceedings was that the property was sold by the assessee for rupees 31 lakhs, but its value for the purpose of stamp duty as per the circle rate was rupees 82 lakhs, resulting in an escapement of income of rupees 51 lakhs. The notice under section 148 was available on the record of the tribunal. The tribunal also had the benefit of perusing the income tax return filed by the assessee. It is on that basis that the tribunal, after duly pursuing the computation of income submitted by the assessee, found that as a matter of fact the assessee had shown a sale consideration of rupees 82 lakhs in the computation of income. Start.